So, why do I share this information with you? I share it with you because during the course of this morning's discussion, you're going to learn information that will help you understand how these cases work. And why is that important? Because during the course of your careers, you may not realize it now, you are going to encounter people who tell you tales of woe, who begin to tell you problems that they've had with a doctor or a hospital. You'll be on the soccer field with your kid, watching the game, talking to somebody. You'll be at Starbucks, getting something to eat, and now you strike up a conversation. And all of a sudden somebody tells you, oh, let me tell you what happened. I was in the doctor and I went in and I had all these problems. The biggest mistake you are going to make is, tell me more. What happened? And now you are going to be stuck in that conversation for at least an hour without being able to extricate yourself. So towards the end of our discussion this morning, I'm going to give you 4 questions to ask that will short-circuit this entire conversation and will give you an immediate sense of whether or not they may have a valid medical malpractice case. And it happens in less than a minute by asking these 4 questions. All right, so let's talk about this scenario. Your client secretly records their doctor in an office visit after a surgical procedure. The patient gets the doctor to admit to the patient in a closed-door setting, yes, you're right, I screwed up, I'm sorry. The patient has secretly recorded this information on his iPhone. He now wants to bring a lawsuit. He comes to you, you evaluate the case, it turns out there is a valid case, and you go forward. And you have this explosive piece of information. Can you withhold this information until the time of trial and use it to ambush the doctor in front of the jury? How many of you think you can withhold that information? How many of you think you can't? The answer is, if you intend on using this explosive information at the time of trial, you are required to disclose this information way before you ever get to trial. You know what would happen if we don't? We're at trial. I asked my client, hey, Mr. Jones, did you record the doctor during this conversation? Yes, I did. And did the doctor know about it? No, he didn't. And do you have that video? Yes. Let's see that video. The defense attorney, as if an ejection button is pressed, jumps up out of his seat, says, objection! Mr. Oginski didn't disclose that to us. He didn't give that to us, as he's required to do. The judge will turn to me and say, Counselor, did you provide this to them before trial? No, Judge, we didn't. That's out, and I can't use it. So if you intend on using that explosive information, give it to the defense as early as you can. And it has another purpose. The other purpose is that once they recognize they've got a problem, now it may actually initiate settlement negotiations and get them to realize that they have a significant problem for which there is no explanation. So don't hold that stuff back. If you've got something your client did, such as secretly record this information, make sure you turn it over to the defense. I'll get to the questions after, okay? All right, so how about this scenario? Your client brings a lawsuit against his doctor, claiming that he was careless and that his carelessness was a cause of his injuries. The doctor, as a defense, turns around and says, why are you suing me? I did nothing wrong. And by the way, what I did was a judgment call. A judgment call based upon my expertise, based upon my experience, based upon my knowledge of this particular condition. I use my best medical judgment in order to render proper treatment to this patient. Don't blame me for something I use my best judgment on. Is that a good defense? The answer is, it's a damn good defense. You want to know why? Because the doctor comes across as being very reasonable and saying, hey, look, I'm doing my best effort, using my best knowledge to go ahead and try and treat your client. And now, I'm sorry, but they did suffer a complication, but it's not my fault. How do we overcome this judgment defense? It was a judgment call. Do you think we can do it? The answer is we can in certain instances. And by the way, juries love this defense.